Welcome, everyone. My name is Elise, and we are excited about engaging in conversation with you, our students, our parents, our advocates. This meeting is brought to you by Georgia Legal Services staff and our race equity team. Our attorneys are excited about sharing their expertise in students' legal rights. We will begin with Eugene Choi, our supervising attorney, providing pertinent information on why this meeting was organized. Then we will give you an opportunity to engage with Kamala Buchanan, our staff attorney who loves working with children and delights in relationship building with her clients. We have Jessica Stewart and Taylor Loin facilitating our chat box and unmuting your phones at the time of engagement. Please review our slides, and we will begin in about 2 minutes, giving people a chance to come on. I said this way too fast. We will begin with Eugene Choi. So it's 4:01 now. We're 4:01, and so I'll give you about another minute for people to click in, and then we will begin with Eugene. Again, thank you for coming, and thank you for being on time. Please keep your phones muted. That's important. Thank you. Bye.
Thanks, Elise. I think I'll give it maybe one more minute.
Okay, Eugene. Everyone knows where their chat box is right now, so why can't we just say hello one to another? And we're giving it one more minute for people to sign in and say hello. So Taylor and Jessica can say hi back. Tell us what area you're from. Are you from Atlanta? Are you from Macon? Are you from Columbus? Where are you from? What city? All right, I see some chats coming in. Oh, 6, 7, come on, come on. Where are they from, Taylor? You hear any, what names, Jessica, what names are you seeing? What cities are you seeing?
We have folks from all over Atlanta, we have Macon, what else? We have, it looks like Decatur, Douglasville, Gainesville, all over. Thanks for coming, everyone.
Douglasville, Decatur, hello. What about Savannah? We have anybody from Savannah?
Yep, looks like we do. Dalton, Conyers, everyone is here.
Everyone is here. All right. Eugene, we will begin with you.
All right, thanks, Elise. So I'm going to give a brief overview of the problems in Georgia's school discipline process. Then, as Elise said, Kamala Buchanan will explain important rights that you have and what you can do to protect those rights. Kamala will be asking for input and questions, and she will go over how to participate when she comes on. So my portion covers some hard truths about school discipline in Georgia. A lot of you will already be familiar with the problems. Some of you may have no idea, and some of you have lived it personally. Next slide. So it's no secret that education is directly linked to employment, and a denial of education has a direct link to poverty. As this chart shows, from 2000 to 2019, the bottom category of employment rates has been and continues to be those with less than a high school completion. Additionally, almost half of Georgia's children live in low-income households, and about a quarter of all Georgia children live in poverty. And of those children living in low-income homes, 89% of those homes are where the parents did not graduate high school. So what does this have to do with school discipline? The more you suspend a child, the more likely he or she will drop out. As you can see, this is a study from Johns Hopkins University, and the more suspensions, the more likelihood, the higher the percentage that the child will drop out of high school. So and this isn't the only study after study show that more suspensions does not increase school safety, it just decreases graduation rates. The pipeline. And some of you, probably the majority of you, have heard the term school to prison pipeline. As you can see, in 2013, over 1 million children were arrested. 96% of those children were arrested for nonviolent crimes, and 30% were under the age of 14. Many of the children who end up in juvenile court get there from school referrals. One public defender has told me that since schools have been out due to the pandemic, juvenile delinquency cases have dropped nearly 80% in her county. Also from the slide, race disparities in Georgia school discipline are the same as Georgia's prison population. So what does that mean? What is a race disparity? This graphic shows data that was collected. It shows percentages. At the top there, the numbers show the amount of students who are enrolled in Georgia schools. 44% are white students, 37% are Black students. However, if you continue down that graphic, you can see that Black students are disciplined at a much higher rate than their counterpart white students. For example, for in-school suspensions, those students who are in-school suspended, 33% of them are white students, but 54% are Black students. For out-of-school suspension, 23% of those children are white students, 66% are Black students, and Black students are twice as likely to be expelled from school at a 2-to-1 ratio versus versus white students. Excuse me. So also, in case you were wondering whether the race disparities only exist in suspensions, it doesn't. As this graphic shows, it shows all the punishments that are available to the school district. As you can see, the light blue represents Black students, the percentage of Black students who are punished. Sorry, I tickled my throat. And across the board, no matter what the punishment is, other than alternative school for non-disruptive students, it's overwhelmingly percentage of Black students who are punished. And I put in the slide because I wanted to highlight a specific transition period. So on the left side, you can see the grade level of children, and on the bottom, and what shows, the bar shows how many students are disciplined per grade. And I've highlighted 7th, 8th, and 9th grade. And all of us know that is a transition period. Children really begin to change mentally, physically. Maturity levels differ at this point. Children often acquire adult features, which can contribute to implicit bias in punishment. But we need to understand that they are still children at this stage. And we need to rethink zero tolerance, excessive discipline, and race disparities in school punishment. All that being said, students and parents do have rights, and I'm very excited to now turn this over to Kamala, who can tell you what you can do about it. Thanks.
Okay, thanks, Eugene. My name is Kamala Buchanan. I'm a staff attorney and a legal fellow here at Georgia Legal Services, and I'm just so excited to be here with you this evening and to hear from you and talk about the issues that you see going on in your communities. So I think I'd like to start by putting up a poll just to get a sense of who all is here and where you're coming from in terms of your educational experience. So I'm gonna go ahead and put up the poll. While you're responding to that, I want to share a little about how this session is going to go so that you kind of know what to expect. I'm really hoping to make this as interactive as possible. I really do want to hear from you. We want to make sure that this is information that's relevant to you or useful to you. And I'm excited to hear your stories because we don't know everything that's going on in the communities. So we're going to hopefully get at your experiences in a couple of ways. Throughout the presentation, we will be posing some discussion questions and encouraging you to share your experiences and perspectives on the issues that we're going to talk about. When I do pose a discussion question, please share your experiences, your responses to the discussion questions in the chat. So type your response into the chat. My colleagues Eugene and Taylor will be monitoring the chat and will share out responses so that we don't have everyone all talking at once. You'll also be asked to participate in polls like these. Aside from this one, these will mostly be designed for you to just sort of reflect on how the information we're sharing impacts your life or relates to your life. If at any point either the polls or the discussion questions or anything I've said brings to mind a story that you want to share, please raise your hand, raise your little Zoom hand. My colleague Taylor will call on you. We'll be monitoring to make sure that we're catching all of those, and I'll go ahead and unmute you and so that you can share your story. We really do want to hear your voice. I don't want you to feel like you can't speak. I really hope that it's not just me talking through this entire thing. So please do raise your hand if you have a story to share. We would really love to hear from you. Last, my colleague Jessica is going to be monitoring the chat for questions. So if a question comes to mind, please put it in the chat. We'll try to answer as many as we can on the fly, and if you, in the chat, and if you know the answer to a question someone else has posed in the chat, please feel free to respond to it. But if there are questions that we didn't get to or that no one could answer, we'll get to those at the end. So we'll be keeping a list of questions that we didn't reach. Looking at poll results, it seems like we have a good number of advocates and attorneys here in the audience, which is awesome. Hopefully this gives you a little bit of perspective on doing your own school discipline work. See that we have several students and a lot of parents, which is great, a couple educators, and it seems like most folks have some form of, or are experiencing some form of distance learning right now, which makes sense. A small percentage of you are going to school fully in person, but it sounds like everyone is dealing with some kind of distance learning, which we will definitely talk about how these rights apply in distance learning. So I'm going to start with one of those discussion questions that I just mentioned. Again, I really want to hear from you. So please, again, type your responses into the chat, raise your hand if you'd like to speak. But I want to start by having a conversation about the discipline issues that you have seen in the schools in your communities. And I have some things to keep in mind to frame your thoughts, but I hope that you'll just write whatever you think into the chat. But I'm curious what you think about how knowing your legal rights can disrupt the school to prison pipeline, why students or their families might not know their legal rights, whether school discipline impacts students of color differently than white students, and if so, how? And lastly, how these issues have changed since the COVID-19 pandemic. Again, I'm going to give you about a few seconds to put your response into the chat, and then I will have my colleague Eugene start sharing now. Eugene, do you want to share a response from the chat?
Sure. So we have one response saying that children are disciplined, including suspension, without representation.
Yeah, that's a really great point. And one thing we're going to talk about is the rights that students have leading up to a hearing. And I think often families are not told by the school districts or by people disciplining them that they can have counsel. So that's a really important thing to highlight and can really make the difference in how a student is disciplined. Taylor, would you like to share another one out from the chat?
Sure. It looks like, you know, someone's commented that as a way to disrupt the school to prison pipeline, that if students know their rights and or they don't know their rights or don't speak with an attorney, it can, or if they do know their rights, I'm sorry, I got that backwards. If they, you know their rights and speak with an attorney, then they can try to, you know, limit being punished. We also have a comment here about a lot of Spanish-speaking parents that have come into the U.S. in the last 20 years. They don't know the school system and the rights that come along with it and the responsibilities of the school. So that's important that people know.
Yeah, absolutely. I mean, what all of these responses I think are hitting on really well is that there's an information gap, right? There's what the school knows, which whether or not it's intentional isn't always communicated to parents or students. And when it comes to having language barriers or things like that, that gap gets even wider. So knowing your rights, knowing
Eugene, I see you moving, but Kamala is down.
So I don't know what just happened. But we're all here. So your thing froze, Kamala. So I guess what we need to do is have that phone number set up but close by, just in case you need to call in, so we can hear you.
There, she's back.
Okay.
And
Okay.
I don't know what just happened.
Yeah, that was very confusing. I think everybody just froze on my end, so I don't know what happened, but I hope everyone can hear me now. If you can just like throw me a little thumbs up or something.
Thumbs up from the reaction bar.
Excellent. And if I hope that you can also see the PowerPoint of a cute little girl in some adorable pigtails asking what students can be disciplined for. If that does happen again, I'll call in quickly. And so hopefully you'll be able to still hear me, but please do let me know if there are any technical difficulties.
And I'm gonna put that number in the chat box, Kamala, so people can have it.
Yeah, great. All right, well, let's just jump right back in. Wanted to start with what students can be disciplined for, because if you know what the rules are, it's easier to follow them. And if the rules aren't fair, it's possible to change them. So 2 ways that you can kind of have a voice in your own rights in this process. When it comes to what students can be disciplined for, each school district has a code of conduct. This code of conduct, basically it lists the rules, what students can and can't do. And it has to go through, it has to be approved by the school board, and it has to comply with Georgia law and federal law and the United States Constitution and the state constitution. So there's a lot of laws that govern what can and can't be in a school's code of conduct, or in other words, what students can or cannot be disciplined for. So for instance, something that we're going to talk about a lot in the second part of our series next week is that there's a federal law that says students with disabilities can't be disciplined for conduct that relates to their disabilities. That's a federal law that schools have to follow that has to be incorporated into their student code. Another important thing to note about the student code is that if something isn't prohibited in the student code of conduct, a student can't be disciplined for it. So if, for instance, your school's code of conduct hasn't been updated since the COVID-19 pandemic hit, a school can't necessarily say, oh, we have this new rule. If it's not in the code of conduct, a student probably can't be disciplined for it. Now, legally, school districts are required to give out the code of conduct to many families. If you're a parent or a student, you probably had to like sign a piece of paper that says, yes, I received this thing. If you're a student, you may have been handed it in your planner or something like that. It's often, it's like a huge booklet. It's really nitty gritty. It looks really boring, but I really encourage everyone to actually read your student code of conduct. It sounds lame and boring, but it's super important because codes of conduct can change every year. So first of all, something that was against the rules in one year may not be against the rules in another year. And the reason those things can change is because students, families, educators, and administrators can push to change them. So as you're reading over your student code, if you're a parent or a student, think critically about what rules in the code seem fair and what rules in the code don't seem fair. If something does seem unfair, you can, for instance, write a letter to your local school board. You can speak out at their meetings and just share your thoughts about what is and isn't fair in your school code. We had a story, I want to share a quick story about our practice here at Georgia Legal Services Program. We had a case, or we had worked in a district that had a code that prohibited representing yourself as a gang member. whether or not you were aware that what you were doing was affiliated with a gang. So theoretically, a student could just show up to school wearing red because they liked that color, but then be in trouble because they accidentally affiliated with a gang. And the school district actually this year changed that policy to require that the student has to know that what they're doing is gang affiliated. So if the student does something by mistake that is gang affiliated, they can't be punished for that. And that's an example of just a student identifying something in the code of conduct that wasn't fair, and then the school district changing that rule to make it more fair. So students can have a really powerful voice in that process. Now here, I just want to focus in a little more closely on a couple areas of discipline that might be especially relevant in like a distance learning situation or an online learning situation. The first thing I want to talk about is off-campus conduct. So many of you may have noticed that sometimes school districts impose discipline for things that don't happen at school. If a student does something on the weekend or after school, sometimes the school finds out about that somehow and says, hey, that was against our rules, you're expelled. Now, legally, the school district can only do that for a small portion of really serious crimes. Can really only discipline students for things that happen off campus for felonies. That's important to know, because if your school comes to you and says, hey, you violated the dress code off campus, they can't discipline you for that because you're not on campus. And in the age of online learning and distance learning, I think it's kind of, people may interpret differently what off-campus and on-campus is. So as a student or a parent, if you do experience discipline for something that happens off campus, you should know that you may have this right that the school district can only discipline you for a felony. The next thing I just want to mention when it comes to distance learning is free speech. Often there's a misconception that students in school don't have any rights to free speech, and that the school can kind of police what they can and can't say all the time. That's not true at all. The Supreme Court of the United States has actually said that students' rights to free speech don't stop at the schoolhouse gates. So students do have rights to free speech. They're not always the exact same as an adult would have in the community, but more than likely, a school district can't discipline a student in a way that violates their free speech rights. So two really important rights here when we're talking about off-campus learning. In order to discipline for something that happens off campus, the conduct has to be a felony, and schools can't discipline students for things that violate their free speech, including things they say online. So a school district can't discipline a student for things they say online. Moving on to investigations, and again, I just want to remind folks that if you have a question or a comment, please put it in the chat. We're monitoring, and there will be other opportunities for like conversation and participation, but if you do have a story to tell, please raise your little Zoom hand.
I have a question, Ms. Kamala. Do you want me to put the poll up we had on discipline, or?
Yes, please.
Okay, and I was looking at the poll. So here we go, everyone.
Thanks. And again, this is just a way for you to interact with the information, think, reflect on it, and how it happens in your community.
People are responding. They're responding fast too.
Great. I'm glad to hear it. Hopefully those results will go up when folks are done, so we can see whether people's schools do generally follow these laws, or if there's been experiences.
He said, don't add, I don't know. I do not know. That's a good one. I will add that next time. Okay, Juan? Okay, I'm going to launch it because someone is asking a question. Here we go. Share results. Can
Yes,
you see
please.
that?
Yeah, interesting. So it looks like it's pretty 50-50. Most folks have said that school districts do generally follow these laws, which is wonderful. A good number of people, about half, have also said that they don't. So I'm glad that most districts have been following that. But if they haven't, now you know, and you can say, hey, that violates my right to free speech. You can't discipline me for that. I'm going to
Good
move on
information.
to sort of the next step in the process. So now we all know what we can and can't be disciplined for. We have thoroughly read our student code of conduct and have had many long and glamorous battles at school board meetings about what is and isn't in those student codes of conduct. But something has happened, and now your school wants to investigate you for something that went wrong. What can they do? What can they do to investigate you? What can they ask you? What can they do to you? PowerPoint is, oh, here we go. So I'll start with questioning. And I just want to note before I get into the details that all of the rights that I'm about to say apply whether a student is being questioned in person or online. So I know that a lot of things are done over the internet right now. If you have to have a Zoom meeting with your principal, you still have these rights. So what are those rights? Well, you, like anyone else who's being questioned, you have the right to remain silent. And not only do you have the right to remain silent, you should remain silent. I think it's often easy when you're in a situation with your principal or your, like the school resource officer, the police person on campus, to think, oh, the best thing to do here in this situation is to tell them everything that happened, because then they'll just understand me. But you, and maybe that's true, but you would be surprised about how the things you say can be twisted and used against you. You don't know necessarily what people's intents are behind asking those questions. So you have the right to remain silent, and you should take that right. You should not be like Homer Simpson. You should just be quiet. The other right you have is to have your parents and or a lawyer present. This is especially true if you're being questioned by the police on campus. So like if your school resource officer is questioning you, you definitely have the right to your parents and a lawyer present. Even if it's just your principal, you have a right to have your parent be there. And I always tell students that I interact with, if someone starts asking you questions about something you may or may not have done wrong, or something someone else may or may not have done wrong, the only words out of your mouth should be, I want my parents and a lawyer present. You can say it totally politely. You don't have to be angry, but I want my parents and a lawyer present. You're golden. And then once your parents and a lawyer are there, you can have a conversation with them and talk about what is or isn't good to say, what you should or shouldn't say in this situation, what would or wouldn't be helpful to the administrator, the school administrator you're talking to, or the police person you're talking to. But having an adult, your parents or a lawyer, especially a lawyer and expert, to sort of bounce those questions off of and think about that before just talking can be really, really useful. Next, we're going to talk really quickly about searches. You can be searched at school. That is legally permissible. Under the law, the school does have to have what's called a reasonable suspicion. So legally, that's a pretty low bar. Like a lot of things can be reasonable suspicions, but sometimes you'll be asked like, hey, can I search this? And even if there may be a reasonable suspicion, you don't have to consent to that. So you can say, again, very politely, if you're a student, I don't consent to this search, and just have it out there. The reason that that's important is because anything that the school gets from searching you against your consent in an unconstitutional way can't be used against you. So if the search was improper, they can't use that information against you as evidence against you later. Now, the last thing about searches is that there are certain kinds of searches that are too invasive to do to kids at school. They're too much, that you can't do them to students at school. And one example of those is a strip search. So you can't strip search a student at school. You can't ask them to remove their clothes. Now, the last note on investigations that I want to touch on are records, and talking about specifically that scenario I mentioned earlier, where if something happens off campus, say a crime happens off campus and a student is arrested by law enforcement in their community, can the school learn about that? Can the school get access to records of the juvenile court proceedings? Can the school get access to an arrest record? Because of that law I mentioned earlier, where something has to be a felony if it happens on campus for a school to be able to discipline, schools often will investigate instances that happen off campus to see if they can discipline students for those incidents. They're trying to find out whether or not something is a felony. And in most situations, not all, but in most situations, students and their parents have a right to refuse to hand over their students' court records. So a scenario that might happen here is say you're a parent, your student's school calls you up and says, hey, we heard somehow that maybe, little Jack got into some trouble off campus. Can you just send us that arrest record? It'll seem like it's not an option, but it is. You don't have to give over that arrest record. You don't have to give over your student's juvenile court records. It's okay to tell your district no, and if they say, okay, well then your student can't come back to school, that's a moment where you really would want to call an attorney. Now, lastly, I mentioned that most of the time, school districts can't access juvenile court records. There are some very rare scenarios where they can, where the crimes are so serious that they can get their hands on them. But even if they can legally, properly access them, schools can't use them against students. So if a student is in a hearing and the school tries to use their arrest record against them, they can't do that, even if they accessed it properly. We're going to talk about hearings next. I want to start here with just discussion about what your right is to a hearing, because it's a little bit confusing. So under the law, if a student will be out of school for more than 10 days, the school is required to hold a hearing. So let's say your student is suspended for 1 school week, so that's 5 days, no hearing for that. You do have to give the student the opportunity to tell their side of the story, but they don't have to hold a hearing. But as soon as the student is out of school for more than 10 days, that hearing right kicks in. And once that happens, it's absolutely 100% 10 days equals hearing. There is no situation where a student would be out of school for 10 days where the school district would not have to hold a hearing. Now, often schools will sort of strongly encourage parents to sign what they call a waiver of the hearing, where the student either admits guilt or says that they don't contest the charges against them and accepts a punishment. And often we've observed sometimes that school districts will present these waivers to parents in a way that makes it really feel like it's not a choice, that it's, hey, your student did this, they admitted it, sign this, they're going to be expelled. But it's always a choice, because that hearing requirement is so important. It's huge, and the school has to have that hearing. So if the school district is saying, hey, sign a waiver, you don't have to do that. You don't have to sign a waiver. And more importantly, you don't have to accept the punishment that the school is suggesting. For instance, if you're a student and you really did have a fight at school, but you feel really badly about it, you can say, like, I know that I did this, but maybe a shorter punishment might be better. I really do feel remorseful. Or if you're the parent, you can say that on behalf of your student. You can kind of negotiate a little what the terms of that waiver are. So if the punishment feels too harsh, or if you don't want to admit that you did it, you don't have to sign the waiver. You don't have to accept what the school district is telling you the punishment is. Now, the last thing I want to note is, let's say you go through the waiver, you're like, no, I don't want to sign it. It's not right. I didn't do it, or it's not fair, or this punishment is too long. You then have to have a hearing, and you have to be notified before the hearing when the hearing is going to take place. And there are really formal requirements in Georgia law for what has to be in that notice. First of all, you have to receive the notice at least 3 days before the hearing. So if the school district says, fine, we're having a hearing tomorrow, that's illegal. They can't do that. You have to have at least 3 days notice, because as we're going to talk about, you have to have time to prepare. The notice also has to state what provisions of the student code of conduct the student is alleged to have violated, what the punishment the school district is going to suggest, and any witnesses the school plans to bring. Now here I want to, here we go, yes. It looks like we do have a good number of folks in the audience who have attended a school discipline hearing. So I want to take a quick moment for some discussion in the chat. Again, if you have a story you'd like to share, please raise your hand. This is a point where I'd really love to hear people's experiences of their own school discipline hearings. But for those of us who have attended a school discipline hearing, please write into the chat what it was like. What did you observe? How did it feel to you? Did it feel fair? Did it feel unfair? What surprised you? What didn't surprise you? Please type your responses into the chat or raise your hand if you have a story you'd like to share, if you'd like your voice to be heard. And again, I'll ask for my colleagues to share out some responses from the chat. Taylor, I'll start with you. Is there a response in the chat that you'd like to share out?
Sure, not specifically about school discipline hearings, but I think we had a comment earlier that I think is really directly relevant to this conversation. And so someone made a comment about how it can be really difficult, or parents feel really intimidated by school administrators, and there's a power dynamic there that makes it hard for parents to advocate for their children. And I think especially we're talking about waivers, and there's a real pressure from the school, and it's really hard to push back and say no. And I think that power dynamic is evident in all stages of the kind of discipline process.
Oh, sure. Yeah. I mean, even from an advocate's perspective, that's true. For me, I'm intimidated all the time. A couple of responses or things that come to my mind in response to that are, first, that it doesn't have to be a big fight. Often the school district isn't necessarily reacting with all of the information. You know your child best. You know what is best for your child. Your student school only sees them in a small part of their lives. So it may just be that you can bring expertise, and you can bring knowledge, and you can bring an understanding of what the right thing to do is that maybe just isn't immediately obvious to your child's school district. The other thoughts I have are just having people to stand by you. Having an attorney is great. Having some other parents who are going through something similar, having your child's mentors or church leaders or aunts, uncles, whoever to be by your side can help make that experience feel a lot less scary. And as we'll talk about in the next segment, can be really helpful to your kid. But I think that's true, and that's something that's really hard. That's a reason that we are advocates who do this work, to be a voice for parents, but it's true at all stages. There's always so intimidating, and it's hard. I agree that it's hard to say to a parent, like, here it is, stand up, do it, because it's really intimidating.
We've had a couple other comments come in. One person shared that in their experience the hearings were biased and basically a rubber stamp of the school's decision already. And I just can't help but echo that. I had the same exact thought when I went to my first school discipline hearing.
Yeah. Have there been other comments that have other responses that have made similar comments, or other thoughts that people have had in the chat? Eugene, feel free to chime in if you have seen anything as well.
Yeah, there have been, there's a couple comments about specific instances. I saw a comment earlier about little things like being rowdy or being late to class or uniform violations, how that adds up and how the school uses that to justify kicking a child out. And then we also, in regards to school hearings, we've also had a comment about schools not letting witnesses testify outside of their written statement, which kind of goes towards, your right to not write a statement. And I think we have, so those are two comments that just came in.
Yeah, those are all really, really great comments. One thing we're going to talk about is, first of all, what these hearings look like, and then also the really important question of what to do if you lose. Because whoever made the comment that Taylor shared is right. They often do feel unfair. Often the people who are making the decisions work for the school district. So it's like you against your principal, who is presenting to someone who they've worked together for years and who you just met today. It's weird. It feels unfair. But we will talk about, first of all, how to make that situation feel a little more fair, and second of all, what to do if you lose. I'm glad that folks are sharing. Please continue to share. It really helps me to sort of know who I'm talking to and what you think of the school discipline process. I want to just share some thoughts next about preparing for a hearing, talk a little about what it looks like. So it basically is a mini trial. It's usually at the school, and they will or at the district central building, and they'll put you in a room, and the school district will tell its side of the story, and then the student has an opportunity to tell their side of the story. And so when you, the student or a parent or the person advocating for that student, are telling your side of the story, first of all, you're allowed to have an attorney or an advocate there, and you can call us, GLSP. If you're in Atlanta, you can call Atlanta Legal Aid. You could just find an attorney in your community who may be able to help you. There's a lot of avenues to get to an attorney. I think I neglected to put it in the slide, but at the end I'll say all of our contact information, our phone number, so you know how to find us if you do need an attorney. You also have the opportunity to call your own witnesses. So people who can speak on your behalf, tell your side of the story. So if, let's say there was a fight, you were involved in a fight and you were just sticking up for yourself, somebody else started it, like if your friends were there, ask your friends, hey, would you be willing to speak out for me at this hearing? Hearings are supposed to be completely confidential. Student witnesses' names are not even in the record. So it's, you know, if you can find witnesses who will speak out for you, it's pretty low risk for them, and you can share that with them. And it can really help to illuminate your side of the story. You also have the opportunity to cross-examine the school's witnesses. So if you're someone from the school goes up and lies or says something that they couldn't possibly know, you have an opportunity to say, like, do you know that? How do you know that? And try to get them to admit that they don't actually know. Now, lastly, students do have the right to testify in discipline hearings, but their testimony is under oath and can be used against them in other courts. So students, parents, and advocates should be really careful about whether or not to have a student testify, especially when the conduct could give rise to criminal charges, like a fight or bringing a weapon to school or bringing drugs to school or anything like that. That's something people should be really cautious about. And as an attorney, I would advise most people, if there are other people, other witnesses who can tell your story, build that story with them, and then as a student, don't testify. Now, I described a little about what happens at the hearing, and I want to sort of like give some illustration to it so that it's not as intimidating walking into it. So like I said, you're in a room, you're at the school, everyone has lawyers, or you are like a parent who is really ready to stick up for your student and tell your student's side of the story. What's going to happen? So the most discipline hearings have two phases. Start with guilt, and then if the student is found guilty, it moves into punishment. In the guilt phase, the school has the burden of proof. So the school has to prove that the student violated the provision of the student code that they were charged with. Now, often schools will bring like administrators who didn't see the incident. So that's an opportunity to cross-examine the administrator. But that's the school's burden. The school has to prove all of that. They have to prove all of the elements of the charges. If the student is found guilty of violating the code, then it goes to the punishment phase. And that's where the comment that Eugene read out earlier about a lot of small disciplinary infractions can become very relevant, because under Georgia law, punishment has to be what's called progressive, that schools have to consider the student's past discipline history, grades, and any other circumstances in assessing what kind of a punishment is appropriate. So often schools will say, well, look, he has all of these disciplinary infractions. She was absent, she was tardy, he didn't wear the dress code, whatever. So they clearly deserve like a really long punishment. But again, that's something you can push back on. It's not just a formula. It's not like, oh, a lot of discipline incidents, suspension forever. You can bring parents or teachers. Often a teacher can be really powerful if there's a teacher your child gets along with really well. People your child interacts with in the community, family members, mentors, again, church leaders. Anyone can come and testify that the student shouldn't be punished harshly for any reason. It could be related to trauma. It could be related to the fact that the student is just really trying to do better, that this is a good kid, that they have all of these services available to them. Anyone can testify at that guilt stage that a harsh punishment isn't appropriate. I'm going to skip through punishments because we're running low on time, but I just do want to note that punishments are limited by what the hearing officer says or what the waiver says. So you can't say suspension for 6 months and then be like, well, actually we're gonna have to ask the student to stay out of school a little longer. No, it's limited. And that is also true of assignments to alternative school. Assignments to our alternative school should also be limited according to what is in the decision of the hearing officer or in the waiver that was signed. Now again, I am gonna kind of cut my comments on appeals short a little since we're running low on time and I wanna have time to answer questions. But remember earlier I said these things are unfair. Sometimes we lose them. I know I've lost stuff. We all have. It's it can be hard, and you can lose even when you think that it's the most completely unfair thing in the world for your student to be suspended or expelled. Even if you lose at the hearing, having that hearing is super important because you have to do what's called making objections at the hearing. So things that feel unfair, or if you're an attorney, things that are against the law, evidence that shouldn't be allowed in, speculation, anything like that. You have to make all of those objections because then you, only if you make an objection are you able to raise it on appeal. So you can't appeal an issue if you didn't object to it at the hearing. And for parents who are unable to get legal help before the hearing, that's also true. Even if you don't know what you're doing, just like object to everything. It feels unfair, object to it. It probably is. You're almost certainly right. Just make objections and build up the record. Like tell your student side of the story because on appeal, all of that stuff really matters. On appeal, appeals go first to the local Board of Education. So let's say you're in Fulton County, you are expelled from a school in Fulton County by a hearing officer. Then you go to the Fulton County School Board and you're like, hey, this is really messed up. And the school board may or may not agree with you. From there, you go to the State Board of Education. And then you can go through the Georgia courts if you're still fighting that. But at the State Board of Education phase, the decisions made by the State Board are binding. So if what happened to you is really unfair and you take it all the way up to the State Board of Education and you're like, this was really messed up, and the State Board says, yeah, it really was, that was super unfair, that means that no school district in the state can do to another student what they did to you. If the State Board of Education says it was unfair, it's over. And that's true all the way through the courts. Our office recently won a victory on a discipline case just like this, where we actually got the Georgia Supreme Court to say that students have a right to self-defense. So this stuff can really matter. Your individual story can really, really, really matter. And just one last point before I close and open up for some brief questions. Throughout the appeals process, you're entitled to an attorney. So even if you handle, like if you can't find an attorney and you're just super stressed and you do the tribunal on your own, congratulations, you're incredible. It's terrifying. You can still get an attorney at any point in that stage. So, yeah, you can have an advocate with you through that whole process. But I hope that I've shared some information that makes the discipline process seem a little less scary, a little more like something, a space where you can assert your rights and have a voice in your own education. And now we just have a couple minutes left to open it up for questions. And I'll just add a reminder that we're gonna have another session a week from today about special education. So more time to talk with us. But,
we do. We only
questions.
have a couple minutes left. So if you have questions, and we respect your time. So if you have questions, put it in the chat bar. And what we'll do is we will respond to your questions when we send out the link so you can view this video again. Is that okay? Or did you want to, does someone have like a question. My dogs are barking. Did someone have a great question they wanted to ask?
Why don't we go to Jessica? And Jessica, if there's a really important question to share out or some information that I missed or misstated, please share that.
Sure, Kamala. A couple of questions we have is one, if you can speak to whether a school can punish a student for putting a threat about bringing a gun to school online.
So likely yes, I would say. It's not 100% clear, and it really depends on the facts, but if the student directly mentions the school, the likelihood is that the school can punish them for it. Again, it depends on the specific nature of the incident, but I would say likely yes. Jessica, Eugene, Taylor, any other questions, or if you have anything to add?
A few of the comments mentioned that parents don't know these rights, or the advocates. A lot of advocates don't. Is there a mechanism? Are parents supposed to be told these rights when they are implicated?
If you are in a situation where your student is facing school discipline, yes, you are supposed to be told these rights. You should be told that you have a right to a hearing and a right to an attorney, and a right to bring all of your own witnesses and tell your side of the story. That's a requirement if you're facing school discipline. If you're not, correct me if I'm wrong, Eugene, Taylor, Jessica, but I don't think so. I think that if you're not facing school discipline, if you're not in that moment, schools don't have any obligation to tell you those rights. And so we do have some Know Your Rights information that we'll be sending out to everyone in this meeting that I hope you'll share as widely as you can, but generally no, unless there's something that has happened.
There was also mention about school 504 plans. Can you generally tell us whether children with disabilities may have different rights or additional rights?
So Taylor is going to go into this a lot more in the next session. Students with disabilities do have a lot of different rights. As a general rule, you can't discipline a student for conduct that is a manifestation of their disability. So conduct that relates to their disability can't be the subject of school discipline.
If we're still doing questions, there's one more. Does the school have to provide representation for the student, like in Superior Court?
Unfortunately, no. It is on the family or the student's guardian to find representation. And I'm just going to say our phone number. It's 833 GLSP law. One of my colleagues should nod if that's correct. 833 GLSPLAW is our phone number, the way to reach us if you are ever in this situation. You can also call Atlanta Legal Aid, Georgia Appleseed, a variety of other attorneys who do this kind of work.
And if you want to save the information on the chat and that we had in the chat room, just click the three dots on the right of your chat bar, and you can save the information. But again, we will send you information, a fact sheet, as well as a link so you can view the video. And we want you to come back next Thursday at today's Thursday or today's Tuesday?
Tuesday.
Oh, next Tuesday on the 29th at 4 o'clock, and invite those, because we're going to talk about school discipline and resources. Resources and school discipline. What are we talking about Tuesday?
Special education, the rights of students with disabilities.
Special education, yes, Taylor, thank you. And resources, so please tell your friends and use the same link, register and invite others. And we will send you the link. We will send you a fact sheet as well as the video so you can view this again. If you want to save your chat, click on the three dots on the far right and hit save. Thank you guys for coming. Thank you, Jessica. Thank you, Eugene. Thank you, Taylor. Thank you, Kamala. Okay, see, now you got your name now. You done got me mixed up with your name. I don't know how to at your name all this time. Thank you guys, and we appreciate you joining our Education, Not Incarceration webinar. Bye.